Welcome to Employment Law This Week. I'm George Whipple. Artificial intelligence is top of mind for many employers and for the agencies that regulate them. On a federal level, we're seeing a marked slowdown in new regulations, with the administration aggressively pursuing a deregulatory, innovation-first approach. Meanwhile, state governments are experimenting with many different approaches to regulating AI, some that directly impact employers. In order to help employers track the fast-moving regulatory landscape, Epstein Becker Green has published a state-by-state map highlighting the legal landscape for AI. Today, we take a look at two of these state-level initiatives. First, Epstein Becker Green's Courtney McFate tells us about California Governor Gavin Newsom's first-of-its-kind executive order on labor protections in the age of AI. The executive order doesn't create immediate new compliance obligations for employers, but it previews where state policy and regulation and enforcement may be headed in California.
This order is different because it focuses on anticipating and mitigating labor market impacts rather than regulating the AI systems directly. It's essentially the first U.S. state executive order to frame AI workforce disruption as an imminent, coordinated policy emergency, basically treating it the way the states treat disaster preparedness rather than a vague future concern. Also, it mandates specific agencies to report on AI labor market research statistics and produce recommendations on updating warrant obligations for AI-driven mass layoffs. This is a first because no state has previously directed a review of mass layoff notification laws through the specific lens of AI automation and displacement.
Moving across the map to Connecticut, we now turn to Epstein Becker Green's Liz Torkelsen to take us through that state's sweeping new AI law, which includes transparency and non-discrimination requirements for employers.
Connecticut recently joined a number of states in requiring more transparency in employers' use of AI in the workplace, specifically automated employment-related decision technology. Starting October 1st, 2027, employers must provide a written notice to applicants and employees whenever they are using AI to process an individual's personal data to generate any kind of output that's going to be a substantial factor or will materially influence an employment-related decision such as hiring, promotion, discipline, termination, or training.
For any action alleging discrimination involving these tools, Connecticut courts may also consider anti-bias testing as evidence of compliance. A good reminder that annual bias audits are a best practice for employers using workplace AI tools, even when audits are not legally required. Tell us, Liz, what makes Connecticut's law unique?
Connecticut's law actually imposes some shared responsibility for compliance with the new law on developers of the automated employment-related decision technology. The law requires developers to provide employers with the information that they need in order to comply with the notice requirements.
The law also imposes new reporting requirements on Connecticut employers when a layoff triggers the Federal WARN Act.
Those employers must provide a written notice to the Connecticut Department of Labor disclosing whether the layoffs are related to the employer's use of artificial intelligence or other technology.
Thanks, Liz and Courtney, and thank you very much for watching. Don't forget to check out our state-by-state AI legislation tracker. We'll see you next time.